Assalamualaikum and hi to our beloved lecturer Dr. Faradila binti Ghazali and to all the viewers here. For this video, we would like to present about our group assignment for the subject Business Law MGM3313. We are from group 17 and I would like to introduce our group members. First one is Aina Salsabila binti Patan Alliance Effendi, Nick Muhammad Amin bin Nid Sharifullah, me, Siti Humairah binti Salmin. Next is Muhammad Izzuddin bin Muhammad Razi. And lastly is Umairah binti Tajul Arifin. And now we move to definition. The Contract Act 1950, specifically Part S, Section 135 to 191, contains the majority of Malaysian agency law. An agent is a person hired to follow instruction for another or act on behalf of another in communication with third parties. The person whose behalf the act is undertaken or who is represented is referred as principal. The agent is the person acting on behalf, represent on behalf of the principal. In addition, the phrase third party refers to the party with whom the agent signs a contract on the principal's behalf. There are numerous ways to establish the agency. Like any other contract, an agency contract may be expressed or implied from the circumstances and the conduct of the parties. There are a few different ways that an agency can start. Number 1, by the principal's express appointment. Number 2, by the principal's implied employment. Number 3, by holding a position that would typically be associated with authority to perform in the Cohesion Act. Number 4, when an agent acts without the principal's authorization, the principal adopts the agent's action through the ratification procedure. And number 5, out of necessity.
So, next I would like to explain the situation based on our case study that we have chose. Okay, so the situation is Ibrahim asked Chong to deliver to Singapore a quantity of durian from Maras. The delivery was late as the lorry was stranded for 5 days because of the flooded road at Gemas. Chong knew Lim, the trader in Singapore, will not take the delivery of the fruit as his past delivery experience tell him that Lim will only accept durian which are young with cluster of the fruit within the shell are still crisp. The hulls of the durian in the lorry now have cracked and most are overripe and unpalatable. To avoid further loss, Chong sold the durian at the roadside at a cheap price without communicating at Ibrahim. Does Chong have the authority to do so? Or can Ibrahim claim the loss from Chong? Alright, so the issue is whether Ibrahim can claim the loss of selling the durian from Chong.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nick Muhammad Amin bin Sharifullah and today I'll be presenting the law. According to Section 142 of the Contract Act of 1950, an agent might, in an emergency, take any step to safeguard his principal from loss that would be reasonable in the same or a comparable scenario. The following 3 conditions must be satisfied in order to establish an agency of necessity. First, the agent cannot receive the principal's instruction. Number 2, under the circumstances, the agent's conduct is necessary to avoid a loss to the principal in relation to the interest entrusted to his custody. And lastly, the necessity agent has to act honestly. I think that's all from me. Thank you.
This is our case, Springer versus Great Western Railway 1921. In Springer versus Great Western Railway 1921, tomato import from Jersey were delayed because bad weather and a dog strike. Decision to sell tomatoes locally was made by the carriers since they were quickly going bad, despite the fact that the court was confident that tomatoes owner would have permits. The carriers were nevertheless responsible to the owner of the tomatoes for doing this, and the agency necessity was not required because the carriers could have gotten in touch with the owner and asked whether this was wanted to do that.
Application. In the virtue of Section 142 of Contracts Act 1950 and the case Springer versus Great Western Railway, Ibrahim gave an authority to Chong to deliver a quantity of durians from Maras to Singapore. due to a flooded road. On the way to delivery, the lorry was stalled for days and delivery was delayed. Chong sold the durians at the roadside for a cheap price without informing Ibrahim, since the durian husks in the truck were now cracked, overripe, and appealing. It is because Chong could have communicated with Ibrahim and asked him if this is what he wanted him to do in order to prevent more loss, but no urgency of necessity existed. However, Ibrahim may be disqualified from claiming losses for the durians sold by Chong if the situation occurs like the case of Great Northern Railway Co. versus Swafield. The conclusion is, even though there has been much discussion about the case, it is clear that Ibrahim can claim for the loss of selling the durians from Chong. This is demonstrated by the case of Springer versus Great Western Railway. That's all from us. Thank you.